Sperry says we don't get to hear this at all, and the court doesn't like that. It doesn't like total exclusions of judicial review. The court doesn't like the Social Security Administration relying on this provision in 1395 II, which seems to suggest that we're just going to keep all of these issues out of the court altogether, because it starts to creep into an area that we talk about in federal courts about the ability of Congress to limit the jurisdiction of the federal courts to hear claims of injury. And that's something that the court generally doesn't like to allow. And so in combination, these two considerations mean that the court is unwilling to read the statute in a way to exclude the kind of review that the respondents are looking for here. Okay? So the takeaways from Bowen on this point, I think I would say, is the court doesn't like to read statutes to preclude review. The presumption holds strong. If there are complex review schemes that are set up by statute, the argument in favor of saying that review is otherwise precluded may very well be good, but not overwhelming. If there are arguments that there are constitutional violations, and you note this discussion by Levin at 622, in the Levin piece by 622, barring constitutional challenges is very hard. The courts are extremely reluctant to read into statutory schemes and intend to bar constitutional challenges to agency decisions. Fourth, the more substantial the limits on judicial review of particular areas generally, the more skeptical the court gets and the harder it works to find exceptions to the statutory scheme or ways around the statutory scheme that might look like it's creating an exception to judicial review. Fifth, there may be a little bit more of an ability of courts, or rather Congress, to set up limitations on judicial review if they're time limited. If Congress says, okay, you can review everything, but you can only do it in the first 6 months after a statute's been enacted. After that, you don't get to do constitutional challenges. That's this issue that you see discussed at page 623 to 624 and 625, involving Yacus, which was the 1944 statute involving pricing during wartime, and Adamo. Finally, on state law, because of the way that Congress is generally viewed as having the ability to limit the scope of jurisdiction of federal courts, state law discussions are usually, okay, sorry, I've had to cut out bits of coughing here and there. In state law, usually there are more substantial limits on the ability to restrict judicial review than are the case under the federal system. Even though the courts are reluctant to do it under the federal system, they'll still do it. In state situations, sometimes there are even state constitutional provisions that very strongly limit the ability of the legislatures to restrict judicial review. On the problems, let's hold on to those. We'll talk about the problems at the end of each of these sections on Tuesday. Okay, let's talk about Heckler versus Cheney real quick. So this is the idea about committed to agency discretion by law. There's some weird tensions here that are talked about in Heckler versus Cheney, right? If you say you don't get to review things that are committed to agency discretion by law, then how do you ever review an agency decision for abuse of discretion, right? Beyond that, if an agency decision is committed to agency discretion by law, then it seems like there's not even an intelligible principle to rely upon to decide whether or not the agency is doing something correctly. And if that's true, then you've got a non-delegation problem. So this committed to agency discretion lives kind of in this strange little halfway world between these two extremes. Yeah, go ahead and review agency discretion versus don't review it at all and get into a constitutional problem. The discussion that you see in Heckler versus Cheney is typical, and here's the way that I think you should think about this after reviewing this case. And this is the case involving whether or not the FDA had to take enforcement action to prevent the use of certain drugs to perform an execution. So the main takeaways to think about when we're talking about Heckler versus Cheney are a few. First of all, with respect to the committed to agency discretion prong of the analysis, the way that the courts articulate this is through this is there no law to apply idea that you see articulated at the beginning of Heckler versus Cheney, and it really comes out of the Overton Park decision, which we've seen discussed in a few places. As Justice Rehnquist puts it, he says, well, this is a situation where review is not to be had if the statute is drawn so that a court would have no meaningful standard against which to judge the agency's exercise of discretion. The idea here is that if the court really doesn't have something to look at, something to weigh against when it's trying to decide whether or not the agency's decision is correct, it makes very little sense for the court to get involved. And so if the statutory scheme is set up so that there's really a wide idea as far as what it is that the agency can and can't do, then so be it. The courts figure that that means that it's committed to agency discretion by law, and they'll just leave the question to the agency. The other prong of this, though, I think is a more important one, and in fact, if you look at Justice Scalia's dissent, which is or I guess it was really his concurring opinion in Webster, which the casebook cites at page 632. Justice Scalia says, look, it's not really this no law to apply, because there's always law to apply, and in some ways I think he's right on this, which is that if there's no law to apply, you've really got a non-delegation problem, because there's no intelligible principle. So there's always some kind of law to apply. There's some touchstone that you can use to evaluate whether or not the agency is appropriately making the decisions that it's making. What this tends to look a little bit more like are these sort of traditional ideas about what exactly is the kind of decision-making that are appropriate for the courts. There is a prong that we'll talk about later when we get to the ripeness doctrine that's phrased in a way that says, is this a question that's amenable to judicial review? Now, in that context, it has to do with timing. Are we going to get more information such that it's more amenable to judicial review later? Here, we're really talking about sort of amenability to judicial review on a much broader level, in the sense that, is this the kind of thing, the kind of decision-making process that the court should get involved in? And to that end, this seems a little bit more like what I might characterize as the political question doctrine or something like that. We don't talk about that separately in this class, but the idea is that there's areas of the law that the federal courts just don't get involved in, that they stay out of because they're political decisions. They're things that have been committed to political decision-making branches by law. This has a similar kind of a feel. And so you see, actually, in Heckler v. Cheney, the kinds of discussions that play out in the context of this prong of the analysis. Justice Rehnquist cites as reasons for not taking this or not reviewing in this case. He says, look, what are the questions that are at issue there? There's questions about the prioritization of resources. How are we going to choose which of the different enforcement actions we should take first, and how are we going to allocate our resources? He says there's a strong likelihood that they're not even going to be able to win in this case, so that we as courts aren't going to do a lot of work, useful work. There are a lot of considerations that go in here about the prioritization of overall priorities. Do we do this? Do we do rulemaking? What are the various choices? And he says, really in the end, this isn't the kind of thing that we're worried about generally, because when an agency withholds its decision to exercise its prosecutorial functions, we're not as worried about individuals' rights being violated. Now, that obviously argument doesn't always work, and it's kind of a classic Rehnquistian argument in the context of this, what about to a death penalty case, right? Obviously, the person who's sitting on the gurney is a little bit concerned about FDA's failure to take enforcement action, even if it may not ultimately be successful. But the point here is that those discussions that Rehnquist enters into on 629 sort of are talking about the different types of issues that are involved in the decision in this case, the decision about whether or not to take enforcement actions, and he comes down pretty hard on the side of, this is the kind of decision-making that really is characteristic of the decision of a prosecutor from the executive branch. These are things that are really kind of exclusively within executive control, and that really the court shouldn't be involved in.